My name is Alan from Grapevine, Texas, and this is a video to the general public about my 7-year-old daughter, Avery. I'm asking for your help to prevent further neglect since the courts and CPS have failed her numerous times. In 2016, Avery was moved 500 miles away, and I spent 8 months in court trying to see Avery. On February 11, 2017, Avery was left in the car at a bar by her mother. The mother's date, Shay Williams, was the CEO of Sunny Glens Children's Home in San Benito, and he was also a child counselor for abused and neglected children. The two got married 6 days later, and they knew each other less than a month. Child endangerment is grounds for termination of parental rights. When the mom got out of jail, CPS gave Avery back to the mother without contacting me. Judge William Harris of the 233rd in Tarrant County said that Avery's mother could keep custody and that jurisdiction was not proper there. In 2016, Judge William Harris could have prevented Liliana Wright's death. I immediately filed another case in Hidalgo County. At the mother's emergency hearing regarding child endangerment and abandonment, Judge Rudy Gonzalez let the mother keep custody because I'd spent 8 months of delays in court trying to obtain visitation rights after the mother's move. The judge thought that moving Avery would be traumatizing for Avery. I filed a complaint with the State Commission on Judicial Conduct. I believe that that's done in the best interest of the child because the judge essentially ruled that my daughter's temporary emotional well-being was more important than her physical safety. In spring of 2020, the mom's husband reached out to me and said that Avery was in a dangerous situation. The police had come out to my daughter's house 7 times in 5 months. Several of these incidents involved the husband and the neighbor, one of which the husband spent an overnight stay at the hospital. Shortly after the mom's husband was hospitalized, he decided to move far away from the Rio Grande Valley to East Texas. The mother's first husband, Clay Rodman, went missing on May 1, 2013 during their marriage. His body has never been located. I never married Avery's mother because I decided it would not be a wise decision. Once the husband, Shay Williams, decided to move to East Texas, Avery's mother and Avery moved in with the next-door neighbor. The mom and the neighbor conceived a child together 2 months later. He was arrested in 2011 for cocaine. He was arrested again in 2012 for assault resulting in bodily injury, cocaine, and marijuana. He was convicted and spent 2 years in prison. While my daughter has been living with him, he was arrested for injuring both of his sons, whom he cannot see or talk to. It's been 3 years since the injuries occurred and 2 years since he's been arrested, and he has still not gone to trial. For these reasons, in July of 2020, I filed a temporary restraining order and it was granted. In September of 2020, Rudy Gonzalez of County Court 1 in Hidalgo County ordered that Avery be returned back to the mother and her boyfriend. Under Chapter 156 of the Texas Family Code, regarding modification of custody, a judge can change temporary orders when the present circumstances would impair the child's physical health or emotional development. So to reiterate, Ramiro Lozoya Jr. cannot see or talk to his children, but County Court 1 of Hidalgo County requires my daughter to live with him. In January of 2021, my case was transferred to County Court 10 in Hidalgo County, and I filed a motion to reconsider Rudy Gonzalez's order. In April of 2021, the 2 injured boys' mother volunteered to come testify in Avery's court hearing.
Has he been abusive to his own children?
Yes, sir.
Can you tell the court how he has been abusive to his own children?
He would choke him. He would hit him with a phone over the head. He spit in my son's face. He used to lock my oldest son in the room on the side while I was at work and I didn't know. He kicked my son and he had a bruise in his arm. In his leg, I'm sorry.
In September of 2021, Hidalgo County Court 10 ordered that Avery remain with both the mother and her boyfriend. The court said that this order was in Avery's best interest. The best interest of the child is a safe, stable, and nonviolent environment according to the Texas Family Code. Knowingly placing a child with someone who is engaged in conduct which endangers a child is grounds for termination of parental rights. Avery has suffered from medical neglect. This is also grounds for termination of parental rights. For the past 2.5 years, Avery has not been allowed to admit that she lives with her mother's boyfriend.
This is my Barbie house I have.
It's Mommy's calling. Don't get mad at me.
Wow,
Don't get mad at me, mother.
that's cool.
Close the door, Avery. Nobody wants to hear your dad, Avery. Come on.
He needs to talk.
I know he could talk, but nobody wants to hear your daddy talk. You know.
I don't know who that was, but yeah.
So that's your Barbie house? On September the 2nd, 2021, Avery was emotionally abused.
So, I don't have very much time because I'm at school and I have a lot to do. First shower, then do my homework, then I don't know, brush my hair, get there in the shower, eat. I have a lot of stuff to do.
Well, we can talk for a while.
Okay.
I'm not gonna let you go outside now. You were supposed to tell him. You were supposed to tell him, weren't you? Weren't you? You were supposed to tell him. I have things to do. And you let him just talk forever. You want to talk to your dad forever? Fine. Go talk to your dad forever. Don't go outside. No. Then why did you not listen to me when I told you? You don't just let him talk forever. He talked for 43 minutes today. You don't need to talk that long. We don't have that kind of time. Next time, you cut him off sooner like you're supposed to. Do you understand? You love talking to your dad that much, you talk to him for the full 2 hours, and then we won't be able to do anything else today. You won't play under tablet, you won't go outside, you won't do any of that stuff. You don't have the time. You tell him you have things to do. You tell him you have to eat, you have to go to bed, you have to do your homework. You tell him that stuff next time. Do you understand? Put your shoes on. Your sister, she's gonna listen.
Endangering the emotional well-being of a child is grounds for termination of parental rights. On September 13th, 2021, I made a CPS report for emotional abuse. The investigator tried to tell me that I reported neglect instead of emotional abuse. When making an online report to CPS, the CPS website doesn't give an option for uploading media.
Okay, well, the allegations are coming in for neglectful supervision. So, you can send that video to me at this number. I'm not sure if you can text it to me, but that would be great, and then I would forward it to her.
Okay, I'll do that.
Perfect.
All right, thank you. The video was too large to send through text message, so I asked her for her email address, and she did not respond. On September 17th, 2021, Judge Mary King filed an order regarding the last 5 months of hearings, which discussed the mother's boyfriend being out on bond for injuring his sons. This order stated that the mother's boyfriend could not be left alone with Avery, and that this is in the best interest of Avery. My attorney presented the argument under Chapter 153.004, Paragraph E, that it is a rebuttable presumption that it is not in the best interest of the child for a parent to have unsupervised visitation with the child if credible evidence is presented of a history or pattern of past or present child neglect or abuse or family violence by that parent or any person who resides in that parent's household. The mom's attorney rebutted by saying that instead of looking at Chapter 153, we should be looking at Chapter 156, Modification of Custody, which states that temporary orders would be necessary because the child's present circumstances would significantly impair the child's physical health or emotional development. The word would implies future tense. How can a judge predict the future of the health of a child? Judge Marroquin's order cites Chapter 153 as to how the order was made. Therefore, Judge Marroquin ignored the credible evidence and the best interest of the child under Chapter 153. Instead of having the endangering parent to have supervised visits like the Texas Family Code suggests, Judge Marroquin required the abusive person in that parent's household to have supervision. Having an endangering parent supervising an abusive person around a child is like having a prison guard go on lunch and asking one of the prisoners to watch after the other prisoners, which is why Chapter 153 of the Texas Family Code is written the way it is.
Real nice. Now they said they're gonna dock my pay, and if I let you out of here again, I'm gonna be severely punished. I don't know. What am I gonna do?
I'm actually surprised they haven't already thrown you in here with me.
No, prison is for bad guys. You're a bad guy, and I'm a good guy.
Yeah, but you can see how, from my perspective, I'm a good guy.
Wait, you're a good guy? It doesn't seem like you understand what your job is.
On the same day the order was filed, I picked Avery up at 6 p.m. and I found many injuries on her. A bruise on her left elbow, a bruise on her right forearm, bruises on her left leg, another picture of her left leg, bruises on her right leg, a burn on her right foot, a cut on her lip, scratches on her throat, symmetrical bruises on the inside of her wrists, a cut on her right hand, a bruise in the shape of a line on her right ankle, a contusion on her left ankle, and puncture wounds on her left thigh. This weekend and the next weekend that I saw her, she was not wearing underwear when I picked her up. Without a video recording of how Avery got hurt, all we have are theories. You're welcome to come up with your own, and here are mine. In 2007, in Minneapolis, a boy fell at a Chinese restaurant while holding his fork and it went through his nose. Here's a picture 2 days after the fork was removed. Here's a side-by-side comparison of the boy's nose after the fork was removed and Avery's leg. At first, when I saw Avery's leg, I thought she had gotten stitches. I quickly realized it wasn't stitches, but puncture wounds from likely a fork. I got a fork from the kitchen and held it next to her leg, partially out of curiosity and partially to substantiate my claims, both criminally and legally.
He used to lock my oldest son in the room on the side while I was at work, and I didn't know.
Here are 2 Google images of people who have been bound by zip ties. And here's Avery's hand again. Here's a side-by-side comparison of the right hand from the Googled zip tie injury next to Avery's right hand. The picture of her wrists again. The contusion on her left ankle. And the line on her right ankle. Here's a Google image of cigarette burns. And the burn from Avery's foot again.
He would choke him. He would hit him with
And here is Avery's neck again. If you try to remove someone's hands from your neck, these are the kind of self-inflicted wounds that you would incur. A cut lip is one of the signs of strangulation. If you've been strangled in the past, your chances of being killed is multiplied by 10. And strangulation is one of the most lethal forms of domestic violence. The natural question you're asking yourself is, what does Avery say? Avery said the burn on her foot came from mac and cheese, and the rest of the injuries came from school on the playground, and then she said she didn't know how the injuries happened. For reasons that I won't go into, studies show that often abused children don't make outcries, or they're delayed, especially when living with their perpetrator. Around Thanksgiving of 2020, 8-year-old Kendrick Lee was murdered in Houston, Texas. His 3 siblings lived with their brother's rotting corpse for approximately a year before the 15-year-old brother finally had the courage to speak out. Within hours of finding the injuries, I filed a police report. The police were not willing to make an arrest or issue a protective order. In the early morning of September 18th, I took Avery to get medical treatment, where they diagnosed her with suspected child. Later in the morning, I reluctantly took Avery to DHR Hospital, where she was diagnosed with assault of a child. The hospitals were required to notify CPS of the abuse, and even though CPS are not medical professionals, they overruled the hospitals and ruled out physical abuse. Also, CPS ruled out neglectful supervision, which nobody reported, but they did not investigate my allegations of emotional abuse. If CPS can't tell the difference between neglectful supervision and emotional abuse, then are they qualified to investigate abuse or attempt to protect children? Under Section Title 4E of the Social Security Act, CPS receives federal incentive money for placing children in foster care and adoption. Nancy Schaefer, a senator from Georgia, spoke out about how this leads CPS children who don't need protecting, and by virtue, not protect children who do need protecting.
It called for family court to be open to the public. Confidentiality and secrecy in family court protects the wrong people. It provided that immunity in the system shall not extend to the seizures of children that are found to be in violation, nor to the administration of medication to a child over the objection of the parent or custodian, and it provided the state from applying for, obtaining, receiving, or accepting adoption incentive payments under the Federal Adoption and Safe Families Act of 1997. The Department of Child Protective Services has become a protected empire built on taking children and separating families. This is not to say that there are not those children who do need to be removed from wretched situations and need protection. However, my report is concerned with the children and parents caught up in legal kidnapping.
Unfortunately, in 2010, Nancy Schaefer died from what's being called a murder-suicide. Are the family courts honest? Do they really want what's in the best interest of the child? Under Title 4D of the Social Security Act, states get incentive money from the federal government for every dollar of child support collected. This is why, when both parents are fit, willing, and able, judges make children spend more time with one parent than the other. Under 201.107 of the Texas Family Code, Title 4D funding contributes towards judges' insurance benefits and retirement benefits. This is what's called the conflict of interest. Under the same chapter of the Texas Family Code, judges are required to take any action necessary to maximize Title 4D funds, and it doesn't mention whether this should be in the best interest of the child or not. After hiring 5 attorneys who couldn't convince 3 different judges to protect Avery, I decided it would be best for Avery for me to represent myself in court. On December 8th of 2021, I wrote the Chief of Police from Pharr, Texas, Andy Harvey, an email. In it, I stated that under the Texas Penal Code, or Texas Criminal Code, Chapter 14.03, officers may make an arrest without a warrant when persons who the police officer have probable cause to believe have committed an assault resulting in bodily injury to another person, and the police officer has probable cause to believe that there is danger of future bodily injury to that person, or persons who the police officer have probable cause to believe have committed an offense involving family violence. I also stated that because additional injuries have been made and will likely continue to be made, I am asking that arrests be made under Penal Code 14.03. If an outcry is needed, then perhaps changing the charges to child endangerment under 22.041C or complicity under Chapter 7 may work in order to offer my daughter protection. I finished my email to the Chief of Police by saying, here are some closing questions I have for you. Will you be pursuing an arrest? If an arrest is not pursued, will you consider requesting a warrant for an arrest? Has the case been closed? If the case has been closed, may we reopen the case with the new injuries and then pursue an arrest? If the department, the civil courts, and CPS will not protect my daughter, then what may I do to protect my daughter as I am required to do by the Texas Family Code 151.01A2, Care, Control, Protection, and Discipline? Because injuries are reoccurring, I consider my daughter to be in immediate danger, so I'd like to see something done soon. The Chief of Police, Andy Harvey, sent me back down the chain of command to speak with the investigator again, and the following is part of that conversation.
Okay, Mr. Young. So the claims that were made was in reference to some injuries. Whenever the child was interviewed, she did not make an outcry, which is the bodily injury for the elements of the crime.
Okay, so when children aren't able to make outcries like babies or things like that, how are those crimes able to be proven?
It's just based off of all the evidence that we have. In this case, sir, we did not have enough. Your child is verbal, so we were CPS was able to speak to her, and she denied any injuries on this case.
In the late summer of 2020, during the 3 weeks that I had her in school at my house, during a temporary restraining order, she started opening up. Okay. So who do you live with? Right, no.
Me, Mom, and Mom.
Okay. What about Ram? Does Ram live there?
No.
Where does Ram live?
Wait. And he lives with his friends and stuff.
Which friends?
The friends that he likes.
Oh.
But would Mom not know this?
No, Mom would not know this.
Yeah.
He does? Well, why can't you tell me?
If I tell Mom that, she's going to be angry.
Well, why would she be angry?
Because she wants to.
She wants to what?
Last time I told her, she got angry and said, Avery, I told you not to say that.
But why did she tell you not to say that?
Because she tells me different things, but can we not talk about this?
Yeah, we don't have to talk about it. But we might have to talk about it later. Well, yeah. Okay. You may recall in January of 2022, 3 teenage boys were arrested for murder for killing a stepfather who had abused his 9-year-old daughter. The stepfather had a warrant for his arrest for continuous use of a different child, but Pharr PD was not capable of locating the fugitive. The Pharr PD chose not to arrest the mother of the 9-year-old for child endangerment or harboring a fugitive.
We had not heard from Quintanilla. Obviously, he's been running from us, and we didn't know of him until he was found deceased in McAllen.
According to 2 different sources, Quintanilla was a police officer for Pharr PD, but for some reason, the mainstream media didn't cover this. Now that I've given you an explanation on some possible reasons why Avery's been left in danger, I'll give you an update on how she's been doing since September. On October 28th, I did a video chat with Avery, and she had a bruise on her leg.
He had a bruise in his arm. In his leg, I'm sorry.
On November the 5th, 2021, Avery had a bruise on her right arm, bruises under her knees, and what resembles fingerprint bruises on her shins, and what resembles a thumbprint bruise on the back of her right calf. On December 3rd, 2021, I found more injuries on Avery. a bruise on her forehead, a scratch on her right arm, scratches on her left arm, bruises and a scratch on her left leg, bruises on the inside of her right leg, bruises on the outside of her right leg, and a bruise on her right forearm. On December 18th, I picked Avery up for Christmas and I found more injuries on her. Bruises which are patterns like fingerprints on her left leg, bruises on her right leg, and a large bruise on the outside of her right upper thigh. On January 23, 2022, I found scratches under Avery's neck. On March 5, 2022, there was a bruise above Avery's left elbow. Here's a side-by-side comparison of the injuries that Avery has had above her elbows. On March 13, 2022, I found more injuries on Avery. Small bruises on her legs, a cut on her right wrist, and a cut on her right hand. The injuries from March 13, 2022 are comparable to the injuries from September 17, 2021. On April the 21st, I had a video chat with Avery and she had more injuries on her. Bruises on her right leg, and bruises on her right arm. On April the 8th, 2022, I filed a 221-page temporary restraining order including the case history as well as 60 exhibits of evidence of Avery's emotional, physical, and sexual. Instead of saying that the present circumstances would impair Avery, we can now finally say that the present circumstances have impaired Avery. This should be enough evidence, right? I emailed the court several times during the next 10 days to try to get an update. On April the 18th, instead of signing the temporary restraining order to offer Avery protection, Judge Marroquin decided to recuse himself or step down from my case. On April the 26th, 2022, the 5th Administrative Judicial Region Judge Missy Madari assigned Federico Hinojosa to Avery's case. 2 days later, on April 28th, Judge Hinojosa, instead of signing the temporary restraining order, which would protect Avery from further emotional, physical, and sexual abuse, instead set a status hearing on May 20th to determine the status of the case and to address all pending motions. This gives Avery an additional 22 days to be. Because this doesn't seem to be enough evidence, then it seems that Avery is put in the similar position of Gabriel Hernandez, that no amount of endangerment or abuse is enough to satisfy the courts, CPS, or the police. As far as case history goes, this documentary ends on May 12, 2022. Because facts and laws haven't been able to protect Avery, I was put in a position to ask for your help. It seems that you are the only one who can protect Avery. Here are some steps you can take to ensure her protection. You can follow Keep Avery Safe on Facebook, YouTube, and TikTok. You can share this documentary from Facebook or YouTube. Here's an important step. You can call County Court 10 of Hidalgo County and ask them to protect Avery under Chapter 153.004 and Chapter 156.006 of the Texas Family Code. You can call the Pharr Police non-emergency line and say, as a concerned citizen, I'm asking that an arrest be made for police report 2021-003-30930 because probable cause does exist. To Avery, I want to say, I'm sorry that I had to make this video, but a safe, stable, and non-violent environment is truly what you need and what you deserve.
I'll get to hold your hand, to be your guiding light in the darkest of nights. I will try to do my best until the day that I'll die. I won't lie, it's not going to be easy, but I'll try. Don't you worry, I'm not going anywhere. I will stay here, I will stay here. And as long as my heart beats like a drum, then I won't back down. No, I won't back down. I know that we will fight and be too proud to say the other one was right. One day you will leave and start your own family. I will try to do my best until the day that I die. I won't lie. It's not going to be easy, but I'll try. Don't you worry, I'm not going anywhere. I will stay here, I will stay here. And as long as my heart beats like a drum, then I won't back down. No, I won't back down. Don't you worry, I'm not going anywhere. I will stay here, I will stay here. And as long as my heart beats like a drum, then I won't back down. Don't you worry, I'm not going anywhere. I will stay here, I will stay here. And as long as my heart beats like a drum, then I won't back down.
Good morning, Judge Savannah Gonzalez for Alan Eoff, and this is Roby Flores is opposing counsel. Judge Cynthia del Bosque is the guardian ad litem in this matter.
Is Ms. Del Bosque available?
I believe she's on screen. I just don't see her image.
All right, and Mr. Flores, identify yourself for the record, please.
Yes, sure. Roby Flores on behalf of Bonnie Williams, and she's in the waiting room somewhere.
It's Bonnie who? Williams?
Yes.
And Ms. Gonzalez, you represent who?
I represent the father, Alan Eoff, E-O-F-F.
Okay. Give me a minute, see if Ms. Del Bosque shows up, and also let me check and see. I think you all may have filed some exhibits. I'm gonna see if I can get those and print them out so I can look at them if necessary.
Judge, the exhibits were related to the order. I have since signed the proposed order that was submitted. What Mr. Flores had submitted was the transcript reflecting that, and it has been accepted already as a proposed order by the clerks.
All right, Ms. Del Bosque, good morning.
Good morning, Judge. Cynthia Cantu del Bosque as ad litem on the child, or for the child.
Okay. All right, so do I need to address anything at this time if you already have agreed to the order that I proposed?
I don't believe so.
Right, I don't think so, Judge. I think we needed to get a status on Ms. Del Bosque. However, my client has brought something to my attention that I don't know if necessarily disqualifies her, but I do feel the need to disclose. When this matter was brought up in 2017, my client is telling me that he consulted directly with Ms. Del Bosque, trying to hire her. I don't know that she remembers that or that that's in her file at any time, but he did consult with her directly for hire.
All right, well, I suppose that would be Ms. Del Bosque's recollection. Also, who do we have on the screen? Is that your client?
In the Dallas Cowboy shirt, yes.
Okay, can you hear us, sir?
Yes.
Okay. All right, Ms. Del Bosque, do you wanna maybe have time to look into this matter to see if Mr. Adolf did actually contact you in 2017 and
Yes, Judge. He didn't mention that to me when I met with him. I do not remember him, and I mean that's a name that would probably stand out. But I can check my files to see if there was a consult back in 2017.
Okay. All right.
Judge, can I interject a little bit? Really, the conflict would be for us, because if anyone would feel uncomfortable with the fact that he consulted would be us. I'm just going to represent to the court that was so long ago. And if she didn't actually get hired, because I was the original lawyer, I never dealt with Ms. Del Bosque in the case. So I don't have an objection on the on that issue. The objection would really be coming from us and not from Mr. Eoff. And based on that, I don't have an objection, Your Honor.
All right, Ms. Gonzalez?
Judge, I just felt the need to disclose that, and I think my client felt a little uncomfortable not having mentioned that earlier, so we wanted to be fair and present that in all candor to the court, Judge.
Okay, well, I mean, certainly it would be an issue for Ms. Del Bosque to tell the court if she felt that maybe she had a conflict. I'm sure that any of you, counsel, would indicate to the court if you have a conflict concern. I'll be with you in a minute. Okay, hold on.
Yes, sir.
Sorry, babe. Are you still on? Are you still on?
Yeah.
Oh, okay.
I'll call it that. Talking to my wife.
My son's therapist is right as the Zoom comes on, and I'm like, wait, just stay with him for 5 minutes.
Yeah.
Guys, I'm not at the office right now, so I don't have my files for the consults from 2017. I would have to look for that. I don't have those.
If the issue is that he
readily.
only talked to you in consult and you really didn't get retained, I don't have a problem.
Yeah,
We're gonna do that right.
I didn't want that to
Sorry.
be an issue that comes up later, and you know, we didn't disclose it. So he did mention it this morning, and you know, just whatever notes are there, especially because it's the same parties, same issues kind of coming up. So I didn't want for that to come back and be something that we're hiding.
All right, Ms. Del Bosque, I'll let you review your notes if you have them, or your consultation back 3 years ago, and then you tell me if you rather not be appointed, then certainly we can consider somebody else. But as far as this hearing or this morning's status, you all have agreed on the proposed orders, and so I don't need to make any decisions or enter any type of orders at this time. All I would say is both for Ms. Is it Williams?
Yes.
Okay, Ms. Williams and Mr. Edoff, right?
Oh.
I'm sorry, and I keep saying it wrong.
That you all continue working together to try to make this matter a lot more easy and more acceptable, rather than be fighting back and forth, especially with the COVID situation and all that. People don't need to be basically bickering back and forth on issues that could be resolved. Okay.
Yes, Judge. I'm going to send over to Mr. Flores. We may have to, if we can, between us, try and agree to a different type of visitation schedule. My client resides in the Dallas area, and previously he was coming back. But I think now that the child is in school, if in fact she has been enrolled, then that kind of limits what long periods of possession he can have. I want to say he was getting about 10 days straight previously, which may need to change now that she's actually enrolled.
The order in place actually provided that once the child was in school, it's like a standard visitation order. So those 10-day provisions are now gone pursuant to the previous order of 2018.
All right, well, you all work it out. If you have any issues on reaching some kind of agreement, you let me know, and we'll accommodate you, and I'll give you a hearing if necessary. I will, though, advise all of you that we are booked solidly all this rest of this month, which is just a few days, including all of next month and all of November and almost all of December. And I'm talking about having at least about 45 to 55 cases every day. So we're booked. So it's going to be very difficult to try to add some more cases when we're booked solidly. Okay.
Yes, sir.
We'll try to work it out, Judge, see what we can figure out.
And if you don't, like I said, I'll try. But as I mentioned to you, this is a very congested schedule that we have, and that's not even including the domestic violence that I handle as well. Okay?
Yes,
all right, you all can be excused. You all take care out there.
Thank you, Your Honor. We have no further business.
Yeah, you all may be excused. All right, Jerry, if you can get me then
Attorney with Tarrant County. I'm calling Alan Oath. You submitted a questionnaire for an application for protective order against Ramiro Lasoya. I'm calling to speak with you about that. My number is again, my name is Norma Bazan, Assistant Criminal District Attorney. Thank you. This is Norma.
Hi, Norma. This is Alan Oath. I got a call from you.
Yes. You submitted a questionnaire for an application for protective order against Ramiro Lasoya.
Yes.
Okay, I'm a little confused with your questionnaire because the incidents that you are discussing are incidences that were back in 2021 and 22, and they're not related to you. They're related to your daughter, Avery.
Yes. May I apply for a protective order for my daughter?
No, sir. Do you have custody of her? Do you have legal custody of her?
Yes, I have joint custody.
You have visitation rights, right?
Yes.
No. You can't apply for her. If you want full custody of your daughter, then you need to go and apply for a modification asking for custody because you're claiming that the boyfriend is harming your daughter in some way.
So, what is a protective order for?
If you have primary custody, you have the right to designate the child's residence, and you feel that the child is being abused by the father, you can file a modification asking the court that the boyfriend not be allowed around your daughter during the times that she is with her mom.
Okay, so you can only file a protective order if you have the primary residence?
Correct.
Is that in the family code, or is that like a DA policy?
No, sir. You don't have the legal right to designate the residence of your daughter, correct?
Right, but I do have joint legal rights.
No. You have the right to file a modification. Why are you not filing a modification if you feel that your daughter is in danger because of the mother's boyfriend?
Oh, I have filed a modification 3.5 years ago.
All right. So nothing came of it. Was that back in Pharr, Texas? Is that where the child resides?
Yes.
Okay. So you can go to the last court order that you have and file a modification asking for that. Looks like you called CPS and tried to get CPS involved. Don't know what happened there. But if you fear that your daughter is in danger because of the mother's boyfriend, you need to get primary custody of your daughter, showing the court that this person is harming her, or get orders that says that this person cannot be around her when she's with her mother. What you're trying to do is get a protective order to keep the child away from mom and his boyfriend. It doesn't work that way. You have a family law court. That family law court can protect your daughter by you going to file a modification and asking for primary custody.
So if the family law court doesn't recognize family violence, then is there any other remedy?
You're going about it a different way. You're trying to come in the back door. You can't do that. If you feel that your daughter is in danger, then you would file a modification asking the court to give you primary custody.
Right, and I did that right after he was arrested for strangling his 2 boys.
Yeah, and so if you feel that you have to do it again, then you can file a modification. It would have to be filed where the child resides. You can't ask for a protective order for someone you don't have primary possession of who is not in your home 24/7.
Even though I have legal rights to my daughter.
You obviously have legal rights to your daughter because you're the father of the child, and therefore you have the right to file a modification asking that you be made primary so your daughter is safe in your hands and not in the hands of the mother and the boyfriend. That is your right as a parent to tell the court that you need to have primary possession because the child is in danger with the mother and the boyfriend.
So parents can't file protective orders. They can only file modifications.
Sir, I'm not going to keep trying to get you. I know you understand what I'm saying. So if you choose to file a protective order on behalf of your daughter, you're welcome to do so. You can do that by hiring a private attorney or by doing it yourself at texaslawhelp.org. texaslawhelp.org has the form. They're free. You download them, you fill them out, you file it with the court. It's free, and you have to have the person personally served. have to have a hearing within 14 to 20 days, and you'd have to present your evidence.
Okay.
And under
Right.
the Texas
All right.
Family
I
Code, you
appreciate
have
it.
to be a member of the family or household, and there's a pretty broad definition there. For children, actually, anyone can file a protective order for a child. You do not have to be a member of the family or household. You can be a next door neighbor. You can be a school teacher. I've even had the amicus in a family case file for one. So for kids, it's a little bit different. But for just a straight up Texas Family Code protective order, there are restrictions on who can file. However, under the criminal code, and we hear criminal code and penal code protective orders for sexual assault, stalking and harassment, trafficking, those kinds of protective orders, you do not have to have any familiar relationship. Those can be done by any person. And sometimes we will see overlap between, and we do often we'll see the filing for a protective order under the family code, which is what I like to call the plain vanilla domestic violence. It doesn't mean that it's less, traumatizing, versus the criminal code. As a member of the family or household, you can be actually file against an ex-spouse or even the new girlfriend or boyfriend of an ex-spouse. So it's a really broad definition because I believe the legislature did understand that families and households are very complex, and that they wanted to make it so people were not limited by who could file and who couldn't file, that the relationships was pretty broad.